Okay, well, let's just move forward. If we can figure it out in the hearing, that would be good, but if not, we will just move forward. Kim Mitchell, are you ready? Wonderful. Good afternoon. Let's come to order, please, and go on the record. I am Commissioner Kimberly W. Duffley, and with me today are Chair Charlotte Mitchell and Commissioner Daniel Klopfelter. I now call for hearing docket number EMP-114 sub-0 in the matter of the application of Oak Trail Solar LLC for a certificate of public convenience and necessity to construct a 100 megawatt solar facility in Currituck County, North Carolina, to be operated as a merchant generating facility. On September 17th, 2020, Oak Trail Solar LLC filed the application for a certificate of public convenience and necessity with 3 confidential addendums along with pre-filed testimony of Matt Crook and Wyatt Toulson. On September 29th, 2020, the public staff filed a notice required by Commission Rule R8-63D with respect to the completeness of the application filed by Oak Trail Solar. On December 14th, 2020, the Commission issued its order requiring filing of testimony, establishing procedural guidelines, and requiring public notice. On February 22nd, 2021, Oak Trail Solar filed supplemental testimony of Matt Crook that contained confidential information. On March 22nd, 2021, the public staff filed the testimony of Evan D. Lawrence, Utilities Engineer of the Electric Division, which contained confidential information. On April 16th, 2021, the applicant filed notice of change of ownership with a confidential amended application and addendum to the direct testimony of Christopher Luer and the supplemental testimony of Matt Crook. On April 30th, 2021, applicant filed rebuttal testimony and exhibits of Frank Bristol. On May 3rd, 2021, both the public staff and the applicant filed their consent to hold the expert witness hearing by remote means. On May 5th, 2021, the applicant filed a supplemental exhibit in connection with the rebuttal testimony of Frank Bristol, filed on April 30th, 2021. On May 12th, 2021, the applicant filed a list of potential cross-examination exhibits and indicated a copy of the potential exhibits were provided to the Commission and the parties of record. On May 14th, 2021, the applicant filed a list of potential redirect exhibits and indicated a copy of the potential exhibits were provided to the Commission and parties of record. On the same date, the public staff filed a revision to Evan Lawrence's testimony. In compliance with the State Ethics Act, I remind all members of the Commission of our duty to avoid conflicts of interest and inquire at this time as to whether any member has a known conflict of interest with respect to the matter before us this afternoon. Please let the record reflect that no conflicts were identified. I will now call for appearances of counsel, beginning with the applicant.
Good afternoon. Thank you, Commissioner Duffley. I'm Merrick Parrott with Parker, Poe, Adams, and Bernstein, here today on behalf of the applicant Oak Trail Solar LLC.
Commissioner Duffley, this is Catherine Ross with Parker, Poe, Adams, and Bernstein, also appearing on behalf of the applicant today.
Thank you. Public staff.
Rita Coxton on behalf of the public staff. With me is Evan Lawrence. We are representing the using and consuming public.
Okay, thank you, Ms. Coxton. Do we have any preliminary matters before we begin?
Commissioner Duffley, I will also announce my appearance as well because I've gotten the video to work.
I saw you when you did not have any conflicts with the State Ethics Act, so welcome.
Yes, Commissioner Duffley, I would love to be heard on a couple of preliminary procedural matters, if I may.
Please go ahead.
Thank you. First, Oak Trail consents to waiving confidentiality of certain exhibits that were filed in the docket as confidential exhibits, and I'll go over which ones they are. Oak Trail consents to waiving confidentiality of the 2 system impact studies, which were filed as application addenda 5 and 6, the facility study report that was filed as supplemental application addendum 1, and the LCOT calculations that were filed as supplemental application addendum 2. We do maintain confidentiality of the other confidential exhibits, specifically the estimated construction costs filed as confidential application addendum 3, the power purchase agreement filed as confidential supplemental application addendum 3, and Leeward's financial statements filed as confidential amended application addendum 2. We don't anticipate that these remaining confidential exhibits will be discussed during the hearing today. We discussed this with public staff previously and believe they are in agreement. Second, sorry, go ahead. Second, I'd like to confirm Oak Trail's order of witnesses. We'd first like to call Christopher Lohr, Oak Trail's finance expert. We would next like to call Mr. Matt Crook, Oak Trail's lead developer. After public staff's witness testifies, we would like to call Franklin Bristol, Leeward's Vice President of Transmission, to testify in rebuttal. And just lastly, we would like to offer a brief opening statement and a brief closing statement at the appropriate time.
Okay, thank you, Ms. Parrott. Ms. Coxton, do you have any response to the motion?
We don't have any objection.
Okay, no objections. And Ms. Parrott, were you going to make a motion to screen share?
I don't believe we will need to screen share, but if we do, we will make a motion prior to doing so.
Okay. Well, thank you for the information regarding the confidential documents and the waivers. Okay, anything further? Okay, Ms. Parrott, you may make an opening statement.
Thank you. Oak Trail Solar LLC is a merchant plant that will interconnect with Dominion's transmission system in PJM territory. Oak Trail is a late-stage development project that has completed the interconnection study process and has entered into a fully executed interconnection service agreement and a fully executed interconnection construction service agreement with PJM and Dominion. There are no affected systems costs assigned to the project and no contingent upgrades related to any earlier queued generators. The project also has a fully executed power purchase agreement. Oak Trail proceeded through the CPCN process without the need for further clearinghouse review and without any public notice or, any public comments or interveners. The public staff is the only other party to the docket. Public staff has indicated that it has concerns about the cost responsibility for potential affected system upgrades in Duke Energy Progress territory, but you will hear testimony as to why such concerns are not applicable to Oak Trail. The public staff has recommended approval of the CPCN for Oak Trail subject to 4 conditions related to affected systems costs and interconnection costs. The staff's proposed conditions are what bring us here today. You will hear from Oak Trail's witnesses why the recommended conditions from Mr. Lawrence are overbroad, unreasonable, and inappropriate for Oak Trail. You will hear that the conditions are not innocuous, but in fact create uncertainty and are a substantial risk to this fully contracted project being able to timely proceed with construction financing and meet its obligations under its contracts, including the interconnection service agreement, interconnection construction service agreement, and power purchase agreement. Finally, as set out in pre-filed testimony, Oak Trail has proposed conditions for the Commission's consideration. Oak Trail's proposed conditions are based on a recent merchant plant CPCN order for the Camden Solar facility that was issued in docket EMP-114 sub-0. Oak Trail and Camden Solar are similarly situated, specifically with respect to the issue of affected system studies and the fact that Oak Trail and Camden both have executed interconnection service agreements. Thank you, and at the appropriate time, we are prepared to call our first witness.
Okay, thank you, Ms. Parrott. Ms. Coxton, did you wish to make an opening statement?
No, ma'am.
Okay, thank you. Ms. Parrott, you may call your first witness.
Thank you. I'll call Mr. Lord.
Good afternoon, Mr. Lohr. I'm going to give you the oath of affirmation. Do you solemnly and sincerely affirm that the testimony you're about to give this afternoon will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may begin.
Thank you. Please state your name and business address for the record.
Christopher Lohr, business address is 6688 North Central Expressway, Suite 500, Dallas, Texas, 75206.
By whom are you currently employed and in what capacity?
I'm the Chief Financial Officer for Leeward Renewable Energy, LLC.
Did you cause to be pre-filed 3 pages of direct testimony on April 16th, 2021 in Q&A form?
That is correct.
Do you have any changes or corrections to your testimony?
No, ma'am.
If I were to ask you those same questions today, would your answers be the same as they appear in your pre-filed testimony?
That is correct.
At this time, I would like to move that Mr. Lohr's pre-filed direct testimony be copied into the record as if given orally from the stand, and that the exhibits to his testimony be marked for identification and included in the record. I believe you are muted. Is that?
Gonna keep myself off of muting. Yes, so approved.
Thank you. Mr. Lohr, have you prepared a summary of your testimony?
Yes.
Okay. Would you please read it for the commission?
My name is Christopher Lohr. I'm the Chief Financial Officer for Leeward Renewable Energy, LLC. My business address is 6688 North Central Expressway, Suite 500, Dallas, Texas, 75206. I have approximately 20 years of experience working in a strategy and financial capacity in the field of large-scale energy infrastructure. I provided pre-filed direct testimony in support of the application on April 16, 2021. The purpose of my testimony is to provide the Commission with background information about Leeward's financial capabilities and in particular the financing of the facility. Oak Trail is a wholly owned indirect subsidiary of Leeward. Leeward has the financial capability and experience to build, own, and operate solar power generation facilities, including this facility. A copy of Leeward's most recent balance sheet and income statement is included as confidential amended application addendum 2. In addition, Leeward has the capability to arrange adequate assurances, guarantees, financing, and insurance for the facility's development, construction, and operation. Leeward plans to use construction loan financing to finance the development and construction of the facility. An additional third party is often brought in later in the development cycle to provide tax equity financing, which allows the project to more efficiently utilize the federal tax benefits associated with renewable energy projects. Leeward and its predecessor companies has owned and operated a fleet of renewable energy assets in the United States for nearly 20 years. Leeward has a strong track record of financing renewable energy projects in the United States and has raised billions of dollars of debt and equity financing. Leeward's projects have been financed by a wide group of global institutions, including JP Morgan, Wells Fargo, Citibank, GE Energy Financial Services, and Union Bank.
Thank you. Mr. Lohr is now available for cross-examination and questions from the commission.
Ms. Coxton?
No cross-examination by the public staff.
Okay, Chair Mitchell? Commissioner Klopfelter? Well, you seem to be off the hook this afternoon. I have no questions as well.
In that vein, I would ask the commission to excuse Mr. Lohr from the hearing if there are no questions.
He is so excused.
Thank you, Mr. Lohr.
Thank you.
Next witness?
We would next call Mr. Matt Crook, who I see on video. Mr. Crook, please state your name and business address for the record.
My name is Matt Crook.
We need to affirm.
Oh, I apologize. Yes.
That's okay. Okay, good afternoon. Do you solemnly and sincerely affirm that the testimony you're about to give this afternoon will be the truth, the whole truth, and nothing but the truth?
Yes. Yes. I do.
You may proceed.
Thank you. Mr. Crook, state your name and business address for the record.
My name is Matt Crook. My business address is 800 Town and Country Boulevard, Suite 500, Houston, Texas, 77024.
By whom are you currently employed and in what capacity?
Leeward Renewable Energy, and I'm a project developer.
Did you cause to be pre-filed 12 pages of direct testimony on September 17th, 2020 in Q&A form?
Yes.
If I were to ask you those same questions today, would your answers be the same as they appear in your pre-filed testimony?
Yes, with one update as to new permits.
Please describe that update.
On pages 6 and 7, I discuss anticipated permits and approvals. Since my filing, the Currituck County Board of Commissioners has issued Oak Trail a use permit that was on November 17th of 2020. And then also the U.S. Army Corps of Engineers has provided an approved jurisdictional determination for the facility.
Thank you. You also caused to be pre-filed 5 pages of supplemental testimony on February 22nd, 2021 in Q&A form.
Yes.
If I were to ask you those same questions today, would your answers be the same as they appeared in your pre-filed testimony?
Yes, with one update.
And please describe that update.
My supplemental testimony stated that Oak Trail had received a system impact study and a facility study from PJM. Since that filing, Oak Trail has entered into a fully executed interconnection services agreement and a related fully executed interconnection construction services agreement with PJM and Dominion. There are multiple deadlines and payments under these agreements, including approximately a $2 million payment for early engineering, construction, and design work related to the interconnection switchyard, which is due in mid-June. Secondly, there's a posting of approximately $5 million security that is due at the end of June. Third, there's a beginning of construction is a milestone for the switchyard to begin on August 1st of 2021. And finally, the completion of all permits, state and local permits, is required by the end of December, so December 31st of 2021.
Thank you. Did you cause to be pre-filed 4 pages of supplemental testimony on April 16th, 2021 in Q&A form?
Yes.
And if I were to ask you those same questions today, would your answers be the same as they appear in your pre-filed testimony?
Yes.
Do you have any changes or corrections to your testimony?
No.
Okay. At this time, I would move that Mr. Crook's September 17th, 2020 pre-filed direct testimony, his February 22nd, 2021 pre-filed supplemental testimony, and his April 16th, 2021 pre-filed supplemental testimony be copied into the record as if given orally from the stand, and that the exhibits to his testimony be marked for identification and included in the record.
Objection.
Thank you. Mr. Crook, have you?
Excuse me, any objection by Ms. Coxton?
No objection.
Okay, without objection, that motion is allowed.
Thank you. Mr. Crook, have you prepared a summary of your testimony?
Yes.
Would you please read it for the commission?
My name is Matt Crook. I'm a project developer for Leeward Renewable Energy, LLC. My business address is 800 Town and Country Boulevard, Suite 500, Houston, Texas 77024. I'm the lead project developer for the Oak Trail Solar LLC solar facility. I have over 8 years experience in the renewable energy field. I provided pre-filed direct testimony in support of the application on September 17, 2020, and pre-filed supplemental testimony on February 22nd, 2021, and April 16th of 2021. The purpose of my testimony is to provide the commission with the background information about Oak Trail, Leeward, and the facility, and to expand on topics in the application for the Certificate of Public Convenience and Necessity, including the regulatory and permitting process for the facility, the need for and impact of the facility, information related to interconnection costs, the applicant's plans to sell the energy and capacity generated by the facility, and Leeward's technical and managerial capabilities. Oak Trail is a wholly owned indirect subsidiary of Leeward. Oak Trail is a limited liability company registered to do business in North Carolina and was organized for the development of the facility in Currituck County, North Carolina, which is subject of the CPCN application. Leeward and its affiliated companies have owned and operated a fleet of renewable energy assets in the United States for nearly 20 years. Leeward owns and operates a portfolio of 22 renewable energy projects across 9 states, totaling more than 2 gigawatts of installed capacity. Leeward and its affiliated companies also develop large-scale wind, solar, and advanced energy storage electric generating assets in North America. Leeward has approximately 14 gigawatts of new wind, solar, and energy storage projects under development across the United States, including an expansive development pipeline of solar projects across more than 20 states. Leeward acquired approximately 10 gigawatts of development stage solar projects from First Solar Inc., including Oak Trail. As part of the acquisition, approximately 50 development personnel from First Solar became Leeward employees. Oak Trail has an agreement with NovaSource Power Services to provide operations and maintenance services for the facility. NovaSource operates more than 1,000 commercial, industrial, and utility scale solar projects totaling 3.5 gigawatts of production and operates across 5 continents in 22 US states. Leeward will have an overall management responsibility for the facility, including all contract compliance, and will coordinate regional technicians to maintain and repair the facility as necessary. Leeward has all of the resources needed to develop, operate, and maintain the facility, such as accounting, human resources, legal, finance, and engineering. The facility includes approximately 878 acres of privately owned land in Currituck County, North Carolina. Oak Trail has options for lease and purchase on private land, which afford the company the right to develop and use the property for solar energy purposes, including the installation of solar panels, inverters, and other elements of the facility. The facility will consist of photovoltaic solar panels affixed to the ground, mounted racks supported on driven piles, inverters, a collection system, and interconnection facilities. A collection substation will be constructed to facilitate interconnection of the facility to the grid operated by DENC. A preliminary site layout, including all major components of the facility, was included as application addendum 4. The nameplate generating capacity of the facility would be 100 megawatt AC, with anticipated gross capacity of 245,000 megawatt hours and a net capacity of 218,460 megawatt hours per year. Solar is an intermittent energy source, and therefore the maximum dependable capacity is 0 megawatts. Per the interconnection request for PJM, Oak Trail has been assigned 67.3 megawatt AC of capacity. There are no network upgrades to affected system transmission assets. The final network upgrades required on DENC's system are reflected in the facility study report that was included as confidential supplemental application addendum 1 and in the interconnection service agreement that was included as Bristol Rebuttal Exhibit A. The levelized cost of transmission for the facility is $1.94, which compares favorably to the average LCOTs identified in the 2019 Lawrence Berkeley National Laboratory Interconnection Cost Study. Furthermore, the entire cost of the network upgrades will be borne by Oak Trail and not reimbursed. The interconnection studies are discussed on page 3 of my February 22nd, 2021 supplemental pre-filed testimony. The interconnection studies are 1, a system impact study for PJM queue position 82160, provided as confidential application addendum 5. 2, a system impact study for PJM queue position 82253, provided as confidential application addendum 6. And 3, a facility study report for PJM queue positions 82160 and 82253. In addition, the facility has a fully executed interconnection service agreement. The facility was determined not to have any impacts on any affected systems, including DEP or any other North Carolina utility. Oak Trail has fully executed power purchase agreement with a large commercial and industrial customer for the entirety of the facility's output, as well as the RECs generated by the facility. The PPA was provided as confidential supplemental application addendum 3. As described on page 6 of my pre-filed testimony, Oak Trail is engaged with Currituck County regarding all necessary county permits and approvals. On November 16, 2020, Oak Trail received a use permit from Currituck County. The applicant has received an approved jurisdictional determination from the U.S. Army Corps of Engineers. The applicant is also aware of applicable state permits and approvals, including those from North Carolina DEQ and North Carolina DOT. The facility represents an investment of tens of millions of dollars into the Currituck County community. Oak Trail anticipates that the county will realize property tax revenues of approximately $134,000 annually from the facility. Also, landowners will receive payments for participating in the facility. A significant benefit of this facility is that it will be privately financed and constructed and will not affect ratepayers. While evidence for the need for this independent renewable facility is strong, any risk of default is on private financiers and not North Carolina retail electric customers. The facility will provide a significant source of RECs for use by electric power suppliers to demonstrate compliance with Senate Bill 3. This facility is expected to generate approximately 218,460 RECs annually. North Carolina has also shown a commitment to clean energy through its Clean Energy Plan finalized by the North Carolina DEQ in October of 2019, which sets a statewide carbon neutrality goal by 2050. The projected demand for renewable energy in North Carolina, DENC, and PJM generally, and the projected increase in demand for solar specifically is discussed on pages 8 through 10 of my pre-filed direct testimony.
Thank you, Mr. Crook. Mr. Crook is now available for cross-examination and questions from the commission.
Thank you. Ms. Coxton?
No cross-examination by the public staff.
Chair Mitchell?
All right, good afternoon. How are you this afternoon?
Doing well.
Mr. Crook. All right, I want to ask you a few questions about your testimony. So a couple of things. I want to first just sort of your summary that you just provided. You indicated that the facility will provide a significant number of RECs for use in Senate Bill 3 compliance. But I thought I understood this deal to be one in which the facility would sell its output plus the RECs to a private purchaser. Is that not the case? Just help me understand what's happening to the RECs here.
The RECs are a part of the power purchase agreement.
Okay, so the RECs are being sold to whoever's purchasing the output of the facility.
Yes.
Okay.
That's my understanding.
Okay. In your testimony filed on the 22nd of February of this year, you indicate that there are no other, you're not aware of any other systems that will be affected by this facility. I'm sort of paraphrasing, but it's page 3 of your testimony. When you all are developing these facilities, just in general, when do you determine, or when can you accept that decision as a final decision? In other words, when is it that you have certainty that there will be no affected system with respect to the facility you're attempting to develop?
That's a good question. And the dates kind of align. And I mentioned in my, I believe my opening, that I would make a change to my testimony in saying that we do now have an interconnection services agreement and an interconnection construction services agreement. That was entered into in March. And I believe my testimony was filed in February of 2022. So yeah, within a week, I would have changed my testimony to say we know versus, you know, a more not anticipated at this moment. Partly because, and there are a couple of things here. First, we have a completed interconnection services agreement. In order to receive that from PJM, they have an interoperating agreement or an operating agreement with DEP and other utilities that they interconnect with, that they're going to check with DEP before issuing an interconnection services agreement to check to see if there's any affected systems. In our facility study and in our interconnection services, our system impact study, it both says there are no affected systems. Again, they've checked with DEP throughout the process of going through the studies for this facility, and then they issue our interconnection services agreement. They would not have issued our interconnection services agreement without calling out affected systems or any contingent systems, any other systems prior in the queue that might, you know, if they drop out, then costs would be borne to this project. They would not have issued the interconnection services agreement that they issued to us.
Okay.
Secondly, and I'll just, this will be the last point, we checked with DEP directly and asked them if there was any affected system upgrade costs to Oak Trail, our specific queue positions. And they, one, have issued a study for the AD2 cluster that says there are none. And they confirmed that there are none for our second queue position, the A2 cluster.
Okay. All right. Thank you for that response. That's helpful. So, just following up there, because I'm hearing you say that the ISA really is the determinative agreement. Once that's been entered into or executed by PJM, you all determine sort of that to be the final, that document to sort of frame your obligations. The charges identified in that agreement that the facility owner and the interconnection customer will be responsible for are identified as estimated charges. And I want to refer you, I think, I know your attorneys will want to know, but I think I'm referring to Schedule E is where the charges are identified, Schedule E to the ISA. And Ms. Parrott, if I've got that wrong, just holler out so that your witness can be directed there. But really, Mr. Crook, my question is, the ISA identifies the charges as estimated. At what point are those, when will we all know the final charges? And what are, I mean, how do you sell, when you go to get financing, how do you explain to your lenders that the charges are more than simply estimated, that you do have some certainty with respect to what you're going to owe under the agreement?
That's right. And so the scope of the charges will not change. So what is being provided in the ISA and ICSA is talking about the facilities costs and network upgrades included in that. There are no affected systems costs that have been identified. And so they can't come back and say there are affected system upgrade costs because they're not identified. But what that is saying is there's cost true up throughout the process. I believe I mentioned in my opening statement that in about a couple of weeks, we'll owe about $2 million in preliminary engineering work that Dominion's currently doing. These costs are trued up at the end. And so at the time of signing in March, they're going to say, here's what the estimated costs are for the facility. But, you know, costs can change, copper costs can change, things like that can change. In which case the price could go down. The facility could actually cost less. It could cost a little bit more, but it's not going to increase exponentially because of an affected system, because that has been identified already as there's no affected system impacts to this facility.
Okay, so what I hear you say then is the scope of the charges isn't going to change, but what happens is there's a true up, and the estimated charges are trued up to actuals, and so what you all owe under what the interconnection customer owes under the agreement can go up or down based on what's actually spent to construct those facilities.
That's right.
Okay, correct me if I've misunderstood you, but that's what I'm hearing you say. All right, that's all for me. Thank you, Mr. Crook.
Thank you.
Okay, Mr. Crook, did you want to finish your answer?
Yeah, I just wanted to also clarify that there's no contingent projects either. So if a project drops out of the queue or something like that, because we have an interconnection services agreement, those projects were not identified as contingent to this project. So even if an affected system, you know, any scope, any additional scope besides our facilities would not be included in the cost true-up.
Thank you. Commissioner Klopfelter? You're on mute.
Mr. Crook's last answer buttoned up the one question I was going to ask. No contingent projects ahead in the queue, so I'm fine. No more questions.
Okay, thank you, Mr. Klopfelter, or Commissioner Klopfelter. So I do have a couple of questions for you, just to follow up to Chair Mitchell's question, and it's a hypothetical. So let's say in 6 months, for some reason or another, there was miscommunication and there are affected system costs. Who would be responsible for those costs in that hypothetical?
One, I don't believe there are any affected system costs, so going to say.
I
or
do
whatever.
understand that. This is just a hypothetical question. If there were, I understand your testimony is there are no affected system costs with respect to this system, and you've shown documentation that you are using to support that. I'm just saying hypothetically, I'm just trying to understand who bears the risk if affected costs somehow materialize after you have started moving forward.
So in that question, you're assuming that Duke Energy has made an error, that they have not followed their own process for identifying affected systems throughout the study process, that PJM has not followed their process somehow with communicating with Duke Energy that, hey, this project is about to receive an interconnection services agreement. You need to review it to make sure it's not affecting your system, and that this project cited perfectly and having all of its things together, all of that hypothetically is done wrong. I believe what would end up happening is Duke Energy would have to reopen. They would have to reopen and show and say, oh, this is why we made a big issue. We made a big error. At that point, they would have to probably, they could try and file something, but they would basically have to reopen, which we probably would not entertain, because if they followed their procedures the way that they should, then this would probably be played out somewhere else, maybe in FERC or something like that. But I'm not probably the best to answer this question. My colleague, Mr. Bristol, can probably get into a little bit more detail with that. But I did want to preface that hypothetical would require Duke Energy Progress to come back and say, we did not follow our own standards. We did not go correctly. We did not do the procedure as correctly done. And I think that's a very highly unlikely hypothetical.
Okay, thank you for that answer. And then also following up on Chair Mitchell's question, we have some staff questions. In your opinion, should the commission withhold issuing a CPCN to EMP applicants until an ISA has been signed?
I can't opine about other projects. I just know the facts of our project, in which says we have an ISA. This is a later stage project, in which case I think the conditions that are being added here really cause more questions. And because they cause more questions, that's more risk on the project for getting financing. We're in a critical juncture. I mentioned a pretty hefty security, additionally $2 million in cash that we're paying for work that's already being done. We have permits that have to be executed by the end of the year. These are things that are real to our project. As far as other projects, if they can verify and show how they don't affect or they don't have affected systems, then potentially. But I'd rather not kind of, I mean, every case might be a little different, but if I believe the facts that we have, the fact that we are so later stage as a project, a stage that has a market participant that has a fully executed PPA, shows the viability of this project.
Okay, thank you. If I could have you turn to your pre-filed direct testimony on page 5.
One moment, sorry. And this is the testimony from September?
Yes.
Page 5, okay.
Okay, down at the line 109, you testify about the county will realize property tax revenues of $134,000 annually. And then you put in a footnote that this $134,000 is based upon, I assume it's the last RPM auction. Is that correct?
Yes, so in order to enter into the auction, the current rules for PJM and that auction, from what we understand, what we gather from our legal counsel, that the North Carolina tax exclusion for solar would be considered kind of an incentive. And so the reason that there's a difference there is if we decide that we want to participate in the capacity market, then we would be likely having to pay taxes, the full 100% of the business property tax. And that's the difference for why that number is different. That is our current understanding.
Okay, so I'm following up with you on that. So is this amount that the tax revenues that would go to the county, are they tied to the price, the clearing price of the RPM auction? So if the RPM auction price, they're getting ready to run another one, if that one goes significantly down, will that affect the revenues to the county?
I think the only thing that would change the two different numbers is the cost of the facility, so the personal property, and how that's taxed. So the tax assessor, whatever they determine the property to cost, and then two, the optionality of we heard the capacity market or not.
Okay, thank you. And could you, just for my own education, you stated that the revenues would increase if you choose the competitive exemption. Could you explain the competitive exemption for me?
Sure. So my understanding is in order to enter into the capacity market, there are rules that say, you basically have to be at the same playing field as everybody else. So take out any state subsidies or any negotiated subsidies. So different states allow for locality subsidies, things like that, in order to make sure that it's competitive. And so that is, I think, what I mean by competitive exemption. So you're basically saying there are no incentives, or what PJM and FERC would consider as incentives for the project.
Okay, thank you. I have nothing further. Are there any follow-ups from the commissioners? If not, any questions on the commission questions?
Just a couple brief follow-up redirect questions, if I may.
Yes. Ms. Coxton, do you have any questions before Ms. Parrott begins?
No question.
Thank you.
Mr. Crook, do you recall Chair Mitchell's questions related to estimated costs in the ISA?
Yes.
And your testimony is that the scope is known, but they are subject to true up post-construction. Is that correct?
That's correct.
And I believe this is clear, but want to make sure it is, that the interconnection costs for the required PJM upgrades will be paid for entirely by Oak Trail, correct?
That's correct.
And no interconnection costs for Oak Trail are passed to ratepayers.
That's correct.
No further questions from me. Thank you. I believe you're muted, Commissioner Duffley.
Thank you. Thank you, Mr. Crook.
Thank you.
Ms. Parrott?
We have no further witnesses in our case in chief.
Okay, thank you. Ms. Coxton?
The public staff calls Evan Lawrence.
Hello, Mr. Lawrence?
Hello, can you hear me?
Yes. Do you solemnly and sincerely affirm that the testimony you're about to give this afternoon will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Please state your name, business address, and present position.
My name is Evan Lawrence. My address is 430 North Salisbury Street, Raleigh, North Carolina, and I'm currently a utilities engineer with the Public Staff's Energy Division.
Did you prepare and cause to be filed on March 22nd, 2021, testimony in this case consisting of 10 pages and an appendix?
Yes, I did.
If the same questions were asked of you today, would your answers be the same?
Yes, with one exception.
Please discuss that.
On page 6 of my testimony, line 29, the phrase AC1 should instead read AD2. Then the section of my testimony beginning on page 6, line 30, with the words "if any network" and ending with page 7, line 9 should be removed.
Other than that change, do you have any other changes or corrections?
I do not.
I move that the direct testimony of Evan Lawrence be copied into the record as if given orally from the stand, and his appendix be pre-marked as filed.
Any objection? Without objection, the motion will be allowed.
Mr. Lawrence, have you prepared a summary of your testimony?
Yes, I have.
Would you please read that for us?
Yes. The purpose of my testimony is to provide the public staff's recommendations to the Commission on the application for a certificate of public convenience and necessity filed by Oak Trail Solar LLC, or the applicant, for its proposed 100 megawatt emergent electric generating facility in Currituck County, North Carolina. The proposed facility will interconnect with PJM. The applicant has complied with all of the Commission's filing requirements to date. However, the public staff has concerns regarding the cost responsibility for potential affected system upgrades in the Duke Energy Progress territory. I recommend the Commission approve the application subject to the following conditions. 1, that the applicant shall file a copy of its affected system operating agreement. 2, that the applicant shall file a verified statement that it is responsible for its portion of any affected system upgrade costs. 3, that the applicant shall notify the Commission of any significant changes in cost estimates. And 4, that the Commission shall consider any costs to be borne by DEP's customers if the applicant seeks reimbursement. This completes my summary.
The witness is available for cross-examination.
Ms. Parrott?
Thank you. This is Ms. Ross. I'm going to take cross-examination of Mr. Lawrence. Thank you.
Thank you.
Good afternoon, Mr. Lawrence. I was starting off, want to make sure we're on the same page, that you would agree that Oak Trail has a fully executed interconnection services agreement, correct?
Yes, sir.
And this was filed in the docket as Bristol Rebuttal Exhibit A on April 30th, 2021?
I believe so, yes.
Subject to check.
Yes.
Something I wouldn't have to say that too often in this hearing, but subject to check, it was filed on April 30th, 2021. And to your knowledge, was it filed with the Federal Energy Regulatory Commission?
I am not aware to that extent. I do know that it does have to be approved by FERC.
So subject to check, we'll say it was filed with FERC.
Yes.
Now I will probably fall into the bad habit of calling this the ISA or the IA, but I'll try to limit acronyms. And hopefully we'll know what each other means. But before we get into the ISA, if we could turn to page 5 of your pre-filed testimony, have a copy of that there with you.
Okay.
And starting at line 10, is this a listing of requests from the commission in their order of December 14th for information from the applicant?
That is correct.
Okay. And looking first just at lines 10 through 11, it says the applicant's requested to provide the amount of network upgrades on DENC, and I'm going to pause there, skip the or any affected systems. So it would read, provide the amount of network upgrades on DENC's transmission system, if any. Did the applicant provide that?
Yes,
And that was approximately $10 million, correct?
yes,
Subject to check if need be. And then going back, if we read those lines again with the part I skipped, it was to provide the amount of any affected systems transmission system, if any. Did the applicant provide an amount of any affected systems transmission system?
there was no known amount to provide, so no. The applicant can only provide what it has available.
And you would agree that sitting here today, there are no known upgrades required on any affected system to interconnect and operate Oak Trail?
I agree.
And there are no affected systems provisions or terms in the executed interconnection services agreement that's been provided?
I agree with that. However, I do not believe that is the intent of the ISA, or the fact that there is the absence of such language means that there will not be any affected system costs.
So let's go through the process for a second. You would agree that the potentially affected systems are consulted during the PJM study process, correct?
That is my understanding, yes.
And there's documentation filed in the record that PJM confirmed PJM consulted with Duke in compliance with its requirements during the study process, correct?
Yes, there is I believe an email you're referring to that has been filed on the docket stating such.
Sure, and I'll note that it's marked as Bristol Rebuttal Exhibit G if you want to turn to it. And you are aware that there's email confirmation from Duke Energy that both of the Oak Trail queue positions have, quote, no impact, correct?
Yes, however, that does not allay my concerns. There are still other places in the affected system study report. Duke has language in there that it reserves the right to restudy. And while it may not be listed now, you know, I haven't seen anything that says for sure that this no affected system costs or upgrades will be required in the future for sure.
Understood. And before we move on to the 82 study and the studies, you have no information sitting here today that the Duke statement that the project has no impact on its system is incorrect or has changed, do you?
No, I don't believe that they provided an incorrect statement.
And sitting here today, you don't have any information from anyone that Oak Trail's facility will have any impact on Duke's system, do you?
No, I do not.
And sitting here today, you don't have any information that the costs, the interconnection costs in the executed ISA are not correct, do you?
No, I have no information stating that they wouldn't, that would not be correct.
Okay, let's turn for a minute to the affected system studies that you mentioned. Setting a little background, you're aware that Duke Energy Progress published affected system studies for 4 of the PJM clusters listed in your testimony, correct?
Yes, I believe that's correct.
Let's turn to Duke Energy Progress's affected systems study for 82. For the commission and your benefit, this was the 6th attachment to the potential cross-examinations that we provided. So I'm going to understand that you have access to all of those potential exhibits and ask you to turn to that.
Ms. Ross, do you want to mark it for identification?
I would very much like to. And we would request that this be marked as Lawrence Cross-Examination Exhibit number 1.
So marked.
Mr. Lawrence, are you at this 82 study?
Yes, I do have that in front of me.
Wonderful. If I can get you to turn to page 2, at the top it says purpose. Can you please read the second sentence beginning with cluster?
It says cluster AD2 includes generation throughout the PJM interconnection, but only those with an impact on the DEP system were included in this study.
And now the 82, well, let me back up. Listed below that on the chart are 4 queue positions in the 82 cluster study, correct?
Yes,
And it's your understanding that those are the 4 82 projects with an impact on the DEP system. Is that correct?
I believe that that's the 4 projects that DEP has noted at that time, and with the parameters known that have an impact on the DEP system. However, in the assumptions paragraph just below that, it says further DEP retains the right to make modifications to power flow cases as needed if additional information is available or if specific scenarios necessitate changes. And to that creates uncertainty about the finalization of these costs and when these costs may be set. We've seen in other cases, and Duke has stated as such that the effective system costs can transfer from one system to or one cluster to the next, and so there is uncertainty there that I believe needs to be addressed.
Now, Mr. Lawrence, understood. Before we go too far, going back up to our second sentence in the purpose, it says cluster 82 includes generation throughout the PJM interconnection. I think we all agree that the 82 cluster in itself has generators that are multiple generation projects. Is that fair?
Yes.
And then the second clause of is, but only those with an impact on the DEP system were included in this study. So at the point in this study that this study is produced, the 82 cluster is known. Duke is looking at those projects. And isn't it correct, based on the purpose here, that it produced this study and only included the projects that had an impact on the DEP system?
That is what that says. However, I'd point to that same sentence below in the assumptions tab.
And we're going to go there quickly.
Changed.
Just want to make sure that we're on the same page in regards to the sentence and the purpose. So looking at the sentence that before we go there, the queue position for Oak Trail is 82-160, correct?
That is one of the 2, yes.
Okay. Yes, the 82 queue position for Oak Trail is 82-160. And you would agree with me that it is not any of the 4 listed in the chart here on page 2?
I agree, it is not listed.
So turning to the sentence that you pointed out, further DEP retains the right to make modifications to power flow cases as needed if additional information is available or specific scenarios necessitate changes. Is it your testimony here today that Duke has the right to make modifications related to any project, or is it that the power flow cases and the specific situations are to those 4 projects listed in this study?
My point to that, I don't see anything in the study or any documentation that I reviewed that says that DEP does not have the ability to study more projects. I don't believe that they are potential or intentionally leaving things out or misleading anybody, generators. However, this study does have these projects, but there is some ambiguity introduced with that language.
Thank you. Appreciate that. Turning, if we may, for just a minute, to testimony of your colleague, Jay Lucas, that was filed in the docket for Oak Solar, formerly Gaston Green Acres Solar, which is EMP-114 on March 23rd, 2021. For the commission and your benefit, this is the 13th attachment to the potential cross exhibits we provided, and we would request that this be marked as Lawrence Cross-Examination Exhibit 2.
It is so marked.
Give you just a minute to get there if I can. Are you there with me, Mr. Lawrence?
I am, yes.
Great. Turning to page 7 of that testimony, lines 17 to 19. Mr. Lucas testifies on March 5th, DEP provided the public staff with its latest schedule for completing affected system studies. Do you see where I am?
Yes.
Okay. And this was in response to the question, what is the latest schedule for DEP's affected system studies for other facilities in PJM territory, correct?
Yes.
And Mr. Lucas provided a schedule that is Lucas Exhibit 1 that I've asked you to turn to.
Okay.
Now, this list was provided to the public staff by Duke Energy, correct?
Yes.
And it is a list of specific queue positions that are pending Duke affected system studies, correct?
That is correct.
And if you look at this with me, there are 4 AD2 queue positions on the list, correct?
I'm sorry, could you repeat the question?
Looking at the first page, there are 4 AD2 queue positions on this list.
And just to clarify, that is A and then D as in dog, 2?
Yes, A as in apple, D as in dog, 2.
Yes, that is correct.
My southern accent might get in the way. And these 4 AD2 queue positions are the same 4 that were identified in Duke Energy Progress's AD2 affected system study that we just discussed, correct?
I believe that is correct. So
Do you want to check?
I can. Yes, that does appear to be correct.
And Oak Trail doesn't appear to be in the list Duke provided to Mr. Lucas, correct?
No, but if they were not in the affected system study at the time, I can't imagine why they would include them in this list. But my previous point still stands.
And looking down and skipping for a minute onto AE2, which is the other queue position for Oak Trail, correct?
Yes.
And specifically AE2-253?
Yes.
And if I could, looking at the list here that is Exhibit 1 to Mr. Lucas's testimony, there are a number of AE2 queue numbers here, correct?
Yes, I do see several here.
Okay. Giving you just a minute to look through those. It is correct that Oak Trail's AE2-253 queue position is not on this list, correct?
It is not. However, I'd say that I have even more reservations about the finalization of those studies, since there has been no study at all completed. At least with the AD2 cluster, there has been a study completed. But even with ambiguity around that, I'd say that's amplified with a study that's a couple clusters away.
Understood. Going back to 82 for just a minute, you would agree that the 82 study process and the report that Duke produced does not include Oak Trail, correct?
Correct. At this time, it does not.
And if we could, sticking with Mr. Lucas's testimony.
I'm sorry. Mr. Lawrence, you're trailing off just a little bit. Can I get you to repeat your answer?
I said I believe my last answer was that is correct. At this time, we
Mr. Lawrence, I didn't want to cut you off. We're good?
yes.
Okay. If we could turn to page 8 of Mr. Lucas's testimony.
Okay, I'm there.
Beginning at line 9, these are the recommended conditions. Again, this is for the Oak Solar project, not to be confused with the docket that we are here today, which is Oak Trail. So I will try very hard to make sure we don't get that confusion. So this is the Oak Solar docket. Are these the public staff recommended conditions on page 8, starting at line 9?
Yes, they are.
Okay. And just, are you familiar with these conditions?
I am familiar with them, yes.
And none of these conditions require the filing of an effective system operating agreement, correct?
That's correct.
And none of these conditions mention anywhere in them affected systems, correct?
That's correct.
And this testimony was filed March 23rd, 2021, correct?
Yes, that's correct.
And is it correct that Oak Solar has an executed interconnection services agreement?
I'm not sure about that. Subject to check.
Subject to check. I'll indicate that it's PJMQ AB1-132, and it was filed as Exhibit 5 to pre-filed supplemental testimony in the Oak Solar docket on February 25th. Now, we talked about 82 and 82, and we talked about the ISA at the beginning of this. It is correct that the interconnection services agreement for Oak Trail includes no upgrades to any affected systems that are required to interconnect and operate Oak Trail, correct?
I'm sorry, could you repeat the question?
Sure. The Oak Trail ISA does not include any upgrades to any affected system that are required to interconnect and operate Oak Trail.
That is what the ISA says.
Now, going to the conditions that Mr. Bristol proposed, which would be rebuttal testimony on page 11. And we would request this be marked as Lawrence Cross Exhibit 3.
So Mark,
Are you with me?
There. Yes, I am.
All right. And if I may have you turn to looking at lines 239 to 255.
Okay.
Have you read these proposed conditions?
Yes, I have.
And is it correct that you didn't object that these conditions be placed on Oak Trail? Your contention is that your proposed conditions, perhaps in addition to these, should be placed on Oak Trail.
I'm sorry, could you repeat that question?
Is it correct that you do not object to the conditions that Mr. Bristol's testimony sets forth? Rather, you contend that the conditions you have recommended, perhaps in addition to those recommended by Mr. Bristol, be placed on the CPCN for Oak Trail?
That is correct. These are conditions that we have filed in other dockets, I believe, as Mr. Bristol notes in his testimony. So.
And so now turning on that note to the the certificate for public convenience and necessity issued to Camden Solar in EMP-109, which I would point to the commission and to the witnesses, was the 9th attachment to the potential cross exhibits we provided, and we would request that be marked as Lawrence Cross Exhibit 4.
It shall be marked as Lawrence Cross-Examination Exhibit number 4.
Thank you. Apologies for not saying the full name.
I have that in front of me now.
All right. And if I could, do you agree that the Camden Solar facility triggered no required affected system upgrades in its interconnection studies?
That's my understanding, yes.
Okay. And would you agree that the Camden Solar facility had a fully executed interconnection agreement at the time the CPCN was issued?
I do believe that is the case.
And now it is correct that Oak Trail is in the same position that Camden Solar was in when the commission entered the order approving Camden Solar CPCN, correct?
To that extent, yes. However, these are different facilities, different areas, different cases. The facts for the case are different. When you point out those two facts there, yes, they are the same. However, I don't believe it's appropriate to narrow down the whole case to those two facts.
Understood. And it's correct that the Camden Solar facility, if you know, is in Camden County, North Carolina, which is a good distance from the seam between Duke Energy Progress and Dominion, correct?
Yes.
And it's fair to say that Oak Trail is in Currituck County, testing your geography, which is also a good distance from the seam between Duke Energy Progress and Dominion, correct?
Yes. However, when these projects are connected, this project, Camden Solar, was connected at distribution level. So that is substantially different than this project, which is connected at the transmission level. And the transmission system is designed to take energy across large areas and large distances fairly efficiently. So the fact that these two projects are different distances away, again, they are very different projects. So those are facts for each, but I don't believe that they have much relation to each other.
One moment. And you would agree that Camden Solar was part of an affected system study cluster, a cluster of affected systems that was studied, correct?
Yes, it was. And sometime after the study, and Duke revised its study, there had been changes made. And so it determined that while I believe that the Camden Solar project was in the AC1 affected system study, those upgrades were later moved to I believe, AB2.
So you would agree that the Camden Solar, while attached, interconnecting with a distribution system, was studied in the same way that Oak Trail has been studied through the PJM cluster process and the Duke affected system process?
Yes.
And if I could get you to turn to what we marked as Lawrence Cross-Examination Exhibit 4.
Sorry, which document was that? I'm not marking those as we go.
Sure. This was the Camden Solar CPCM order.
Okay. I
Bear with
have
me
that in
while-
front of me whenever you're ready.
Bear with me while I get there as well.
Thomas Ross is looking at, for the document. How are you doing, Kim Mitchell? When would you like a break? Okay.
Thank you. So looking at the CPC and order for Camden Solar, turning to the 4th page of that order, there are 4 conditions that the commission placed on Camden Solar, correct?
That is correct.
And are these 4 conditions similar to those that have been proposed by Oak Trail through witness Bristol's rebuttal?
That is correct. But again, these are 2 very different projects.
And if I may get you to address at the beginning, there was a change to your testimony that was filed that removed pre-filed testimony beginning at page 6, beginning on line 30, which started with if any network upgrades for 4 to 6 other clusters are necessary to need altercation. Am I in the right place?
Yes, yes.
And that revision to your testimony was filed on Friday, correct?
Yes, that is correct.
And was your testimony, it was filed and revised because that paragraph is not accurate, correct?
That is correct, yes.
And if you look a little further down on page 7, line 13, do you see where I am?
Yes.
You state that because of the tentative nature of projects in the queue, costs can be shifted from one cluster to another. Do you see that?
Yes.
And it is correct that that sentence should also be struck from your testimony as not being accurate?
No, that is incorrect. That sentence should stay. As we've seen, as Duke has filed in comments, I believe it is a document in these, and it's E100 sub 170 comments. It stated themselves that they've moved costs from and upgrades from one cluster to another. So that sentence is still accurate.
And it would be correct that it would move, costs could move with respect to certain projects from one cluster to another, but it would not be correct that projects such as Oak Trail that had no upgrades required, upgrades to an affected system required through the study process, no costs would be could be attributed to them from one cluster to the next, correct?
I disagree with that statement. I've not seen any evidence that states that these affected system costs are final. I've seen things that suggest that at this time that this is the best known information, but I've seen things actually to the contrary of them being final, that the affected system costs and studies can change as more information becomes available. And I don't know, and the public staff, we aren't aware of at what point that final date is, whether it's when the facility is constructed, when further studies are completed, or if it is final now. We have not seen information that says when they are final.
Now, Mr. Lawrence, you would agree that if a later queued project is contingent on a prior queued project, that contingency would be reflected in the interconnection study reports for the later queued project?
If a network upgrade is required for a project to connect, it is listed in there, yes.
And there are no contingent upgrades related to earlier queued projects in any of the Oak Trail studies or in the executed ISA, correct?
That is correct, none are listed at this time.
Bear with me one moment. Thank you, Mr. Lawrence. At this time, Commissioner Duffley, we have no further questions.
Okay, thank you, Ms. Ross. Ms. Coxton?
I just have a few questions on redirect.
Okay.
Mr. Lawrence, would you remind us what your recommendation is in this docket?
I'm sorry, could not hear you.
Would you remind us what you're recommending in this docket?
Yes, I am recommending that this certificate be approved and that it be approved with conditions that the public staff feels necessary to protect ratepayers.
And would you remind us what the public staff mission is?
We have a duty to protect the using and consuming public, and I believe in this case it would be ratepayers of Duke Energy Progress or any other that may be affected by these projects.
And then I would like to go back just to 2 points that Ms. Ross mentioned. She discussed and distinguished between the current docket and 2 other EMP dockets. And so would you agree that the public staff's approach in evaluating EMP dockets is nuanced and ever evolving based on how things in the industry are changing?
Yes, absolutely. Every project is different. Our process is evolving. We look at each project individually and decide on the recommendations that we believe are best. It's not a one-size-fits-all approach by any means. It's not meant to be, and we have to do what's best for ratepayers and what we feel is fair for the facility.
And would you agree that our recommendations in this docket are intended to protect North Carolina retail ratepayers from uncertainty in the affected system study cost process?
Yes, I would agree with that.
No, nothing further.
Okay, thank you. Chair Mitchell?
All right, good afternoon, Mr. Lawrence. I have a few questions for you. And I will be quick. So, all right, let me get my notes together here. All right, so I'm going to sort of start at the end here, following up on a question your counsel just asked you. So in this case, the public staff is recommending that the CPCN application be granted, and you all have proposed several conditions that the commission should attach to that approval. And I want to ask you about that 4th condition, which it's on page 10 of your testimony. At least begins on page 10 if you want to look at it to refresh your recollection. But in short, the public staff recommends that if the applicant seeks reimbursement for any costs associated with interconnection, I'm paraphrasing there, that the commission weigh those costs to be borne by DEP's retail and wholesale customers with the generation needs in the state or the region, consistent with its order in the Frisian docket. So from a procedural standpoint, help me understand the public staff's recommendation. What are you all envisioning filing a motion for reconsideration, or the commission's exercising its authority under 6280? I mean, what does the public staff envision there with respect to that specific condition?
Well, That of course plays into our recommendations that the cost updates be filed. And so through the cost updates, we look, and if we believe that at some point the costs rise to a need to be concerned, I don't believe, certainly would not limit ourselves to what we think would be appropriate. I'm not sure at this time that I can comment very much on what would be appropriate, what the appropriate amount would be, the appropriate procedure. It's difficult to say now, but I just think whether it be through just an informational filing or rise to the need of a motion for reconsideration, I believe that is something we would reserve.
Okay, and thank you, Mr. Lawrence. And I certainly don't expect public staff to have a range of appropriateness or sort of an articulated level of concern at this point. But I just was curious about what you all were envisioning from a procedural standpoint. It does seem, though, that you all are thinking about sort of an ongoing review or at least continuing sort of oversight of costs associated with the project. Is that correct? With this project and with others, I assume?
Yes, and it is my understanding that is not already, or that may already be covered within the statute. I, of course, I'm not an attorney, but this is a way to, at the bare minimum, to put it on paper and to make an applicant aware of it. We want to be upfront with them. We want, we don't want a situation to arise in the future and then all of a sudden someone be blindsided by something. We want to be fair and we want to be consistent. And this is one way to approach that.
Okay. Understood. Thank you for that response. We've talked some today about the affected system study costs that are identified for projects. I understand that none have been identified for this project, and I've heard you discuss or mention uncertainty with respect to certain costs or lack thereof associated with this project. And so help me understand, at what point in time does the public staff consider costs to be final? Because right now, I understand your testimony to be that they're at least with respect to this project, you all are not there yet. You don't consider these costs that are identified in the ISA to be final. But will the public staff ever get to that place of feeling like the final costs have been identified for the project?
Well,
and that's a complicated question, and I apologize, but I think I think you can understand my concern. So you can just speak to it.
yes. If it's okay with you, I'd like to recharacterize the final costs as more of where we believe there's a small enough risk to ratepayers that we're comfortable with, because I'm not sure ever at what point there are final costs. However, with earlier acute projects such as the Camden Solar project, the project and EMP-114 sub-zero, there were studies that had been completed after those projects for clusters. One was the AC1 cluster. There was we're at the AD2 and D as in dog cluster that has been completed, and seem to be far enough removed from that we're comfortable with no affected system costs being assigned there. And for this project as well, on that front, there's also an AE2 interconnection queue number. And so that raises this to a little bit more of a concern. So, once we're a couple studies past that, we'd be comfortable. And, we can be comfortable with this project as well before that point through other means as well. That certainly isn't the only way. There was some sort of verification from some party certifying that there wouldn't be costs passed on to ratepayers. We'd be comfortable with it at that point without having to know the certainty of the project costs or the affected system costs.
Okay, can you speak a little, just follow up there, Mr. Lawrence? Verification, what are you envisioning there? What do you, be specific about what you all would find helpful?
Well, in my recommendations, sorry, I'm just reviewing them to make sure. So under the second one, we asked for a verification stating the applicant's understanding the costs are recovered, are not able to be recovered by ratepayers under the current OAT. A verification from the applicant stating that they will not seek recovery of any potential costs. Again, understanding that right now there are none identified. Something from Duke Energy, a verified statement from them stating that the costs for this specific project are final as from an affected system point, and that there are a $0 costs and it will remain that way.
Has the public staff had conversations with any of the utilities about that kind of statement? I mean, is that something that you all believe that the utilities would be willing to provide?
We have not. We are working with utilities, specifically Duke Energy Progress, to get meetings set up to further understand these issues and processes and potential for cost shifting and when the final costs are. And so those conversations are being had, but at this point, we have not.
Okay. Okay, thank you. Mr. Lawrence, in your testimony on page 8, you reference the filing that DEC and DEP made at the FERC back last fall. And I guess Duke Energy Florida made the filing as well. It pertains to the ASOA template under the OAT. Essentially, just paraphrasing, the filing would provide that the affected system network upgrade costs shall be solely funded by the customer. Is there any? Can you provide us with a status update there? Has the FERC taken any action there, or has any party taken any action at the FERC with respect to that revision sought by the Duke utilities?
I am not aware of any action that has been taken. I don't know that there hasn't been. I don't know that there has. I do know that since that provision has been made, so since October 1st, Duke has filed with FERC some executed affected system operating agreements with the language in it, and they did come back without problem. Duke does discuss that, and I believe that is their reply comments in the E100 sub 170 docket, but that doesn't necessarily mean acceptance of that language to me. That means that no party challenged it, and so if a party were to challenge it in the future, I don't know that FERC would not overturn that.
Okay, so that brings me to my next question. So what if another party wholly unrelated to Oak Trail filed some sort of challenge at the FERC to that revision that the Dukes have made to their OAT and the associated agreements under the OAT. And then for whatever reason, Oak Trail benefited from a change that the FERC approved, such that Oak Trail were then able to seek reimbursement of costs that it otherwise incurred to interconnect or upgrade networks or systems to facilitate the interconnection of its project. So would what would the public staff's position be with respect to those costs? I mean, Oak Trail, by no fault or reason of its own, benefited from a change from this type of change.
Well, in that situation, there would have, of course, had to be the affected system costs. I would believe that would be the most likely scenario, since this PJM process has been in place for a substantial amount of time. And I believe FERC has explicitly approved that. And so, at that time, if there were system upgrade costs, affected system upgrade costs, and then they were able to recover them, I believe we have contemplated that, and I'm not really able to speak to the legality of whether that would stand. I do know of course, we have attorneys here who did consider that and did evaluate it. And
so under that scenario, does the public staff think that the CPCN for the facility should be revoked? I mean, what does the public staff think is the appropriate consequence there?
Not necessarily revocation, but I believe it would need to be considered. Similar to how the Frisian case was, that was such a substantial amount of costs at the time that, of course, we did not believe that was fair for ratepayers. And so I do believe that is an extreme example. But of course, if this facility hypothetically came back and had $220 million worth of affected system costs that were going to be passed on to Duke Energy Progress ratepayers, we would have a substantial problem with that. And I believe at that time we would ask for the status of the CPCN to be reevaluated.
Okay, understood. And then just help me, last question for you, Mr. Lawrence, and I appreciate your hanging in here with me. We're getting close to the end of the day. So when a customer seeks reimbursement for costs that it outlays, it goes to the utility for reimbursement, correct?
I believe so.
When an interconnection customer, just so the record's clear, when an interconnection customer is looking for reimbursement of costs, it goes to the utility for such reimbursement. Is that right?
Yes.
Okay. And then the utility comes to the commission to seek, among other types of costs to be recovered, that bucket of costs that it's had to pay out to the interconnection customer. Is that right?
Yes.
Okay. So is the public staff thinking, I mean, how do we, if the interconnecting customer is allowed to recover from the utility, the commission's only recourse is as to that utility, right? I mean, we would tell the utility, you can't recover these costs. I mean, is that what the public staff is? Help me sort of understand the public staff's position with respect to what to do with costs that materialize under this scenario of sort of subsequently allowed reimbursement.
Right. That is a complicated situation, and I believe there would be issues in this situation from FERC approved costs telling a utility that they cannot recover those costs.
Right.
I don't know, again, the legality of that, but I believe that is one reason why we are recommending the conditions that we are, to at the earliest point possible, if those costs arise, for us to know about it and to be able to try to make a determination on the situation with minimal risk to everybody involved.
Okay, understood. And last question, in the discussions that you all have had and continue to have with the utilities about, as we all learn more about the study process for these big merchant facilities, are we going to see an improvement in the timing of these studies and the transparency of these studies? I mean, are we going to see some sort of change here in the way this information is provided to regulators, to market participants?
I hope so. As far as the market participants go, we've had asked for these conditions in other dockets where the applicants have accepted it. So other applicants are willing to take that risk. They believe that that risk is appropriate for them. Overall, it seems that market participants aren't unhappy with any ambiguity around these issues with these studies. I believe it would be very helpful for us in these situations if it was more clear. And with the amount of generation that's seeking to interconnect into the PJM system in North Carolina, I'm not sure that this process is going to get faster or on an individual project level. That it would just take an extreme amount of manpower to accomplish. So, those are, of course, all concerns. However, from our end, if at some point we will feel comfortable that the Dukes change to their effective system tariff stands, and the customers won't be able to recover costs for the expected system upgrades. And at that point, when they're not able to recover costs from PJM, they're not able to recover costs from Duke, the impact to ratepayers on every side is going to be minimal for those projects. So, I do see this improving, but at what point, I don't know.
Okay. All right. Thank you, Mr. Lawrence. I have nothing further.
Thank you, Chair Mitchell. Commissioner Kloppfelter.
I do not have any questions.
Okay, Mr. Lawrence, I have a few questions. First, like to follow up on the line of questions from Ms. Ross. It seems like the witnesses for the applicant are stating that all projects within a PJM study cluster are not interdependent with each other, and that some projects within a study cluster can require upgrades, and some projects within this study cluster will not require upgrades. What is your response to that? Do you agree with that statement?
Yes, I do, especially for these clusters. We see what's here in North Carolina, and however, PJM, these clusters are for all of PJM, which expands over several states throughout the Northeast. So they absolutely do not include every project in that cluster. It would only be the ones for the affected system in the general vicinity of North Carolina. It's hard to, I don't think there is a hard boundary of where they may or may not be, but I do agree with that characterization of theirs, yes.
Okay, and then they provided you some evidence that since their Q numbers were not within the affected systems study, that there were no affected systems associated with this project. And I believe I heard, and I just want to confirm what I heard, that you're not positive that it will remain that way. Is that an accurate characterization of what I heard your testimony to be?
That is correct, yes.
Okay, and then they also, the applicant seems to suggest that when a facility is physically located very far away from the DENC DEP seam, that it's highly unlikely to have affected system cost. Do you agree with that? Or do you feel like affected system costs can be, or they can be triggered by a facility far away from the seam?
I believe the farther away you go from an area, the less likely you are to impact that area. However, as I stated earlier, the transmission system is designed to carry energy over a long distance and a large area. So where the project is located is absolutely not free of affecting DEP's system. I'm not saying that this one absolutely will, or that ones will in the future, but one, if the right conditions were present, one in Currituck County could have impacts on DEP system.
Okay, and then turning to your testimony on page 7. So witness Bristol disagreed with your testimony that costs for earlier queued facilities can be pushed forward to the Oak Trail facility if earlier queued facilities drop out of the queue. And I heard you on cross-examination state that you didn't agree with that. Can you just further explain why you believe that these cost shifts from one cluster to another can happen?
So I believe within my testimony, this project does have an ISA. Their PJM costs are set, but for affected system costs, Duke, and they discussed this in their, I can't remember if it's their reply comments or initial comments in the E100 sub 170 docket, but they do state that costs and upgrades for one cluster they have seen them shift to another cluster because of changes within the generator sizes and projects that stay in the queue, or if projects drop out, that might extend the need for a system upgrade to a later date. And so that we have seen examples of that. That's not just a possibility, it has been a reality.
Okay, thank you, Mr. Lawrence. I have no further questions. Questions on commission questions? Ms. Ross.
Yes, very briefly, if I may. Mr. Lawrence, Oak Trail, as the applicant has stated in its testimony, that it will not be reimbursed for the interconnection costs outlined in the studies and in the executed ISA, correct?
It has stated that, yes.
And your recommended condition, did I get there? Number 2 that you referenced as a verified statement. Your condition is not only asking the applicant to make a verified statement, which we would submit they already have, acknowledging under the current Duke Affected Systems Business Procedure and PJM's OAT that it would not be reimbursed. But you are also asking in your conditions for the applicant to make a statement that it prospectively gives up some potential hypothetical legal right should the world change at some point. Is that a fair characterization of the conditions as proposed and drafted?
I'm sorry, did you state that in the testimony, it had been stated that this facility would not seek reimbursement of the any affected system costs or just the PJM costs.
Any interconnection costs, which would be both network upgrades and affected system costs. The applicant has stated that it would not seek reimbursement for those costs.
Okay.
And again,
I have not seen, and I certainly could have misread that in the testimony and application that it says the affected system costs. I've seen where the applicant has stated about the PJM costs.
okay.
And so to the extent that the applicant has stated that it would not seek reimbursement for those costs in its facility, and you say that would be a verified statement, then I don't see any issue. I don't see why the applicant would have any issue with simply filing a letter stating such.
Sure. And just again, making sure the record's clear, there are no known affected systems upgrades required for Oak Trail as we sit here today.
As we sit here today. Yes.
And in each of the conditions, there's a reference to affected systems, each of your proposed conditions. And the first one states the applicant shall file a copy of an executed affected system operating agreement, correct?
Yes.
And there is no ASOA for this project, correct?
Right. And so that would be as applicable. And of course, you cannot file something you don't have, but.
Thank you. That would be our contention. And you've talked about in response to Commissioner Duffley's questions about cost shifts, turning back to page 7 of your testimony, correct? And I believe there was a reference to what starts there as line 3. If generated projects.
I do not believe she referenced a specific place. It was a general reference, but.
Okay, then I'll reference starting at the bottom of page 6 and going into page 7. Is this the portion of your testimony that you testified earlier was removed?
Yes, and in my answer, I did state that, this portion of the testimony would have applied to the PJM interconnection costs, and I did state that at this point those costs are known, and so there is no potential for cost shift. And
Great. Thank you, Mr. Lawrence. At this point, we have no additional questions.
Ms. Costin?
I have just a few. The first thing I'd like to go back to is there were some questions raised about sort of the proximity of the facility to the seam between the utility territory. And is it fair to say that in the public staff's mind that the location relative to the seam is important, but is not necessarily dispositive because of the sheer amount of solar that may be interconnecting in the future? So we have concerns that extend further out than might be immediately obvious because of that.
that is correct, and I'd just like to reiterate that a facility in Currituck County with the right conditions could absolutely have effects on DEP system.
Okay, and then to go back to what you were just discussing with Ms. Ross, in our mind, the testimony, Oak Trail's testimony seems to set up a distinction between interconnection costs and affected system costs. Is that how we interpret their testimony?
Yes, that's correct.
And we interpret their testimony that the interconnection costs are known and they are covered in the document they've executed with PJM.
Yes.
Our concern is that there are affected system costs yet unknown, because all studies have not been completed, or some projects are in nascent stages or whatnot, and that's the reason why there is uncertainty in our mind about affected system costs. Is that correct?
Yes, that's correct.
And then part of the reason that we are recommending that the CPCN be issued with these conditions is to protect ratepayers if something was not 100% accurate in those early affected system determinations.
That's correct.
Nothing further.
Okay, thank you. And for clarification of the record, my question regarding the cost shifts, I was looking to Mr. Lawrence's testimony on page 7, lines 12 through 16 of his original testimony. Are there any questions now with that clarification from Ms. Ross or Ms. Coxton on that?
Not from me.
Okay, thank you. So I will take motions.
We have no motion.
Do you want to move in your cross-examination exhibits exhibit 1, Lawrence cross-examination exhibits 1 through 4?
Yes, apologies. I thought we'd taken those as we went through them. Yes, we would like to move Lawrence cross-examination exhibits 1 through 4 into the record.
Any objection?
No, Commissioner.
Without objection, that motion is allowed. And for safety's sake, Ms. Coxton, have you moved in Mr. Lawrence's testimony and his exhibits?
He doesn't have exhibits. I would like to move in his testimony if I did not do that at the beginning.
Any objection?
No objection.
That motion is allowed. Ms. Coxton, anything further?
Nothing further from the public staff at this time.
Okay, thank you. Kim Mitchell, it is 4 o'clock. Do you need a 5-minute break? Okay, well, let's keep moving forward. Ms. Ross?
Absolutely. At this time, we would call Frank Bristol to the stand in rebuttal.
Mr. Bristol, do you solemnly and sincerely affirm that the testimony you're about to give this afternoon will be the truth, the whole truth, and nothing but the truth?
I affirm.
Thank you.
Mr. Bristol, if you would, please state your name and business address for the record.
My name is Franklin Bristol. My business address is 6688 North Central Expressway, Suite 500, Dallas, Texas, 75206.
And by whom are you currently employed and in what capacity?
Leeward Renewable Energy. I'm the Vice President of Transmission for Leeward.
And did you cause to be pre-filed 12 pages of rebuttal testimony on April 30th, 2021 in Q&A form?
I did.
And do you have any changes or corrections to your testimony?
I do have one correction.
Would you please describe that correction?
There was a cost figure in the original testimony that appeared inaccurate compared to the, I would call it a typo, but inaccurate compared to the filed ISA. The cost should be noted as $10,002,324.
Great. And would that be on page 3, lines 60 to 61 in your testimony?
It would.
If I were to ask you the same questions today with that correction, would your answers be the same as they appear in your pre-filed testimony?
They would be.
At this time, I would move Mr. Bristol's pre-filed rebuttal testimony be copied into the record as if given orally from the stand, and that the exhibits to his testimony be marked for identification and included in the record.
Any objection?
No,
Hearing none, your motion is allowed.
Thank you. Mr. Bristol, have you prepared a summary of your testimony?
I have.
Would you please read that for the commission?
My name is Franklin Bristol. I am the Vice President of Transmission for Leeward Renewable Energy, LLC. My business address is 6688 North Central Expressway, Suite 500, Dallas, Texas, 75206. I have over 25 years experience working in an interconnection and transmission capacity in the field of large-scale energy infrastructure. I provided pre-filed rebuttal testimony in support of the application on April 30th, 2021. The purpose of my rebuttal testimony is to respond to the testimony of public staff witness Evan D. Lawrence filed on March 22nd, 2021, and to provide alternate proposed CPCN conditions for the Commission's consideration. Specifically, I disagree with the following statement made by public staff witness Lawrence at pages 6 and 7 of his testimony. The facility is part of PJM's AD2 and AE2 interconnection clusters. If any network upgrades for 4 to 6 other clusters, AB2, AC1, AC2, AD1, AD2, and AE1 are necessary or need alteration, they may need to be completed before the facility can begin full operation. If generator projects from these previous clusters do not come to fruition, the planned upgrades could be pushed to later clusters. If projects from these previous clusters do come to fruition, additional upgrades may be needed for Alpha Delta 2 and Alpha Echo 2 that cannot be studied until there is more certainty regarding the size and placement of the interconnected generators. Mr. Lawrence also states at page 7 of his testimony that, quote, because of the tentative nature of projects in the queue, costs can be shifted from one cluster to another, end quote. I disagree with this characterization for Oak Trail for the following reasons. The PJM network upgrades for Oak Trail facility are known. Oak Trail is a fully executed interconnection service agreement that was provided as Bristol Rebuttal Exhibit A. The only network upgrades identified in the ISA are related to building and integrating the new point of interconnection substation. No required upgrades to any affected systems were identified in the study phase, and no upgrades to any affected system were set out in the ISA. The PJM interconnection costs identified in the ISA are final and not subject to modification. If generators from previous PJM clusters do not come to fruition, those planned upgrades cannot be pushed to Oak Trail. If any of the planned upgrades assigned to earlier queue generators in the PJM queue were considered contingent for Oak Trail, they would have been identified as a contingent upgrade in Section 3 Delta of Oak Trail's ISA. No such contingent upgrades related to earlier queued projects were identified in the ISA. Moreover, the PJM interconnection costs will not be subject to reimbursement. Per the ISA, Oak Trail is responsible for the PJM interconnection cost, and per PJM's ode, the PJM interconnection costs identified in the Oak Trail ISA are not subject to reimbursement. The ISA does not alter the facility's previously calculated levelized cost of transmission. The PJM interconnection costs identified in the ISA are identical to the costs in the facility study report provided as confidential supplemental application addendum 1. Public staff states that it did not disagree with Oak Trail's levelized cost of transmission calculation, quote, but because of the tentative nature of projects in the queue, costs can be shifted from one cluster to another, end quote. However, as discussed, no cost can be, quote unquote, shifted to Oak Trail because Oak Trail is not contingent on any project in the queue. Public staff witness Lawrence states that Oak Trail was not aware of any impacts to affected systems at this time, but this is not accurate. All interconnection studies are complete. The ISA is fully executed, and both PJM and DEP independently have indicated their concurrence that the Oak Trail queue positions Alpha Delta 2-160 and Alpha Echo 2-253 have no effect on DEP as the affected system in the PJM studies. As part of the CPCN application filed on September 17, 2020, Oak Trail provided the PJM system impact studies for both its Alpha Delta 2 and Alpha Echo 2 queue positions as confidential application addenda 5 and 6. Both studies include a section related to affected systems, and both report that no impacts to DEP were identified. In addition, the ISA does not identify any affected system costs. Had there been any required upgrades to any affected system, PJM would have included such upgrades in Schedule F to Oak Trail's ISA that was filed with the FERC. The DEP affected system studies are available on the DEP Oasis website for the following PJM clusters listed in public staff witness Lawrence's testimony: Alpha Bravo 2, Alpha Charlie 1, Alpha Delta 1, and Alpha Delta 2. Oak Trail is part of PJM's Alpha Delta 2 and Alpha Echo 2 interconnection clusters. The Alpha Delta 2 DEP Affected System Study Report was provided as Bristol Rebuttal Exhibit B. This report does not identify Oak Trail as having an impact on DEP's system. DEP's Affected System Study Report for PJM's Alpha Echo 2 cluster has not yet been published on DEP's OASIS website, but Oak Trail System Impact Study for Q position Alpha Echo 2-253 states that, quote, no Duke Energy progress impacts were identified as part of this study, end quote. DEP has confirmed this via email provided as Bristol Rebuttal Exhibit D. Again, Oak Trail's fully executed ISA includes no affected system upgrades, and therefore whether DEP's Affected System Study Report for PJM's Alpha Echo 2 cluster has been published is irrelevant to Oak Trail. PJM's OAT requires PJM to coordinate with any identified affected systems during the interconnection study phase and include the results in the system impact study or the facility study. As shown in Bristol Rebuttal Exhibit C, PJM confirmed that DEP determined the project has no impact on their system and that, quote, no further DEP study is required, end quote. Furthermore, Bristol Rebuttal Exhibit D is an email from DEP that states, quote, DEP transmission planning has confirmed these projects have no impact, end quote. This email was in response to my request for confirmation that DEP agreed with PJM's statement that DEP reviewed the Oak Trail Q positions Alpha Delta 2-160 and Alpha Echo 2-253 during the interconnection study process and, quote, determined there were no impacts to their system, end quote. Information in the E-100 sub 170 docket supports that Oak Trail does not affect DEP's transmission system or customers as discussed on pages 9 through 10 of my pre-filed rebuttal testimony. In the E-100 sub 170 docket, DEP stated it implemented a change to its standard affected system operating agreement effective October 1st, 2020 that eliminated the reimbursement of affected system network upgrades to interconnection customers. Public staff witness Lawrence's testimony referenced DEP's reimbursement elimination and stated public staff agreed with the change. Mr. Lawrence stated that, quote, if there are no impacts to the customers of electric public utilities, the public staff takes no issue with the application, end quote. Additionally, in the E-100 sub 170 docket, DEP emphasized that, quote, the affected system study process only impacts a relatively small slice of interconnection customers that are seeking to interconnect near the seam between the transmission assets of two separate transmission owners. Oak Trail is located far from DEP's system and any quote-unquote seam between DEP and DENC. Oak Trail objects to the proposed conditions listed in the public staff witness Lawrence's testimony because they are not narrowly tailored to the facts of Oak Trail. As I have outlined, the interconnection study phase is complete. There are no affected system impacts for Oak Trail. Oak Trail is responsible for the cost of the network upgrades identified in its ISA without reimbursement. Oak Trail is a late-stage project with a fully executed ISA and a fully executed PPA and has various upcoming contractual deadlines it must meet. The public staff's recommended conditions are not applicable to Oak Trail, may cause confusion, and are likely to delay Oak Trail's ability to timely secure project financing. Oak Trail has proposed alternate conditions, which are substantially similar to the 4 conditions attached to Camden Solar LLC's CPCN issued in September of 2020 and docket EMP-109 sub-0. Oak Trail's proposed conditions are set out on pages 11 and 12 of my pre-filed rebuttal testimony.
Thank you, Mr. Bristol. Commissioner Duffley, at this time, we would tender the witness for cross-examination by the public staff and questioning by the commission.
Ms. Coxton, we cannot see you, but are you still with us? Ms. Coxton? Okay, why don't we take a 5-minute break? Let's be back here at 4:17. That will give her time to get back connected.
Okay, John, testing my audio in case we need it.
Audio video look good. You're good to go.
All right, thanks.
Sure.
John?
Yes,
Okay, just making sure that you can see and hear me after my IT issue over here. Thank you.
sure, no problem.
Okay, let's go back on the record. Do we have everyone? I thought I saw Miss Coxton.
I'm back.
Oh, good. Okay, so it is now for, the witness has been tendered for cross-examination.
No cross-examination from the public staff.
Okay, Chair Mitchell?
All right, good afternoon. Just a few quick questions for you, Mr. Bristol. The public staff suggests that the costs associated with the interconnection of this facility are not yet final. And I understand the company's position to be, or the applicant's position to be here, that the costs as identified or the charges as identified in the ISA are final. Obviously subject to the true up that I've already discussed with your colleague, but is this, do I understand the applicant's position correctly?
The cost estimates in the ISA are final.
Okay. So is it the applicant's position then that no additional charges are going to be identified that you all will have to cover? So at this point, you don't anticipate any affected system costs being identified at some point in the future that you're going to have to cover?
I don't anticipate any affected system costs being identified, given the coordination that has already taken place between PJM and DEP, and then the fact that we've ended up with a fully executed FERC-filed ISA with no Schedule F. If there were going to be any potential affected system upgrade costs, if they were either known because DEP had determined them, or if they were going to be identified in the future, it would be referenced in Schedule F of the ISA.
Okay, thank you. You've expressed some concern in your testimony about the public staff's proposed condition number 4. And again, paraphrasing your testimony here, but you state that the conditions could cause confusion and delay in the ability of the LLC to obtain financing. Can you explain there? Just help us understand that testimony.
So I'm clear, can you direct me to where you're seeing condition 4? I want to make sure I'm talking about the same condition. I can look in my exhibits or look through my notes if you'd like me to.
Yes, let's see. One second, please.
Commissioner Mitchell, if it's helpful, I believe the conditions are on page 10 of Mr. Lawrence's pre-filed testimony, which was filed March 22nd, 2021.
Thank you, Ms. Ross. And so refer to those conditions there, and then Mr. Bristol, my paraphrasing of your testimony is taken from testimony, or is based on testimony that occurs in your pre-filing on page 10.
My pre-filing?
Mm-hmm. Yes.
Okay, yeah, I mean, the nature of my concern is that having conditions that make it look like there's still studies to be done or upgrades to be identified can be problematic when we talk to potential finance partners. They hire independent engineers to look over what we're doing, and then anything that looks like it has to be confirmed or wrapped up can cause delays.
Okay, but delays in your ability to secure financing or close on financing, just what, help me understand why that's a concern.
I mean, I direct you back to our chief financial officer's testimony earlier today that we need to, we have to get a construction loan before we can get bring in tax equity partners later on, and having conditions that are difficult to explain attached to a CPCN can delay that approval process.
Okay.
And it's preferred to not have conditions because, especially in this instance where the studies are done, we've got confirming emails, we got a pretty tight bow wrapped around the study process here, and then to have a condition that makes it look like the studies aren't done, that can be problematic to explain.
Okay. All right. Check my notes just to see if I got anything else for this witness. Just a general question I'm going to toss at you, Mr. Bristol. In your opinion, how should the commission evaluate network upgrades and affected system costs when considering CPCN applications for EMPs?
Okay, so can you be more specific? Like, what do you mean how? Like timing wise?
How should they factor into our analysis as to whether to award an applicant the CPCN that it seeks?
Yeah, I mean, I can't speak for projects in general. For our project, I mean, I think we should look at the facts in this case, and the facts in this case is I don't believe the commission should have any concerns. The studies, are done. Effective system analysis is conducted during the interconnection study process. The impact study shows there are no effective system upgrades. There could have been a chance for a restudy at the facility study phase, but that didn't occur because there were no effective system impacts. So there were no effective system upgrades identified in either the impact or facility study. Then we got to a final ISA with no Schedule F, affected system impacts or charges. And then we had a FERC filing and no intervention for Duke Energy Progress.
Okay, understood your testimony today and your position today and the applicant's position today as to the specific Oak Trail project. But my question was just a general one. In general, how should the commission consider this type of cost when evaluating whether to award an applicant a CPCN?
I mean, to me, I don't feel like at least in these circumstances where we have no affected system costs, I just don't feel like that there's really a risk to the ratepayers in North Carolina. I don't see why that there's a belief that there's a risk in this circumstance. And I think you guys are concerned about neighboring projects. I think I've seen some examples of some pretty large cost estimates for early stage queue projects, and you're concerned that you're going to potentially have this flood of upgrades that could potentially be subject to reimbursement. But we don't have that case here. We don't have any affected system impacts identified. We don't have any costs subject to reimbursement. And I think that if the facts were different, if we were dancing around affected system upgrade costs and things of that nature, then that would be a different conversation. But there are no impacts in this instance, and there will be no impacts in this instance. And this discussion earlier about queue churn and the like, those facts are just not applicable to this project. It's not set up to occur that way.
Okay. All right. Have you ever been involved in a project? Are you aware of a project, a proposed interconnection, where charges are identified subsequent to the issuance of the ISA?
I'm not aware of that occurring since you use the ISA, I assume you're talking about PJM, because that's a PJM acronym. I'm not aware of getting to a signed interconnection agreement where after the interconnection agreement signed, where a new upgrade would suddenly be identified. That I've seen instances where there's an ISA signed that has condition. It could be somewhat conditional, where you could have contingent upgrades identified, and if the circumstances around the contingent upgrade change, the cost allocation could change. But that's not the case here. If we had contingent upgrades, they would be in that specification section of the ISA. They would be laid out. They list them out in the interconnection studies. If there's higher queued projects that have upgrades in common, they'll show you in the impact study. They'll go through queue by queue and show you everybody contributing to an upgrade, and they'll go multiple queue clusters deep after the triggering project. And then as their study process changes, they'll show the changes to that list. But they don't just suddenly identify a new funder of the upgrades. The upgrades are identified in the impact study, and they'll even say, if it's applicable, there's an upgrade that you may have cost responsibility for if certain things change. But that did not occur here. In this instance, the impact studies are very clean. There is no reshuffling of the queue and assigned upgrades to Alpha Delta 2-160 or Alpha Echo 2-253 due to changes in higher queue generation. It just doesn't exist in this instance.
Okay. Just following up on your comments. So you have seen instances where cost allocation among projects in a cluster changes as the study process proceeds?
Prior to the ISA, I have seen impact studies, I have seen re-studies get issued, and then and study conditions change, but they were not completely unknown changes. There was the potential for that occurrence was already identified in the impact study, and then through a subsequent re-study, those impacts change.
Okay. All right, I have nothing further.
Commissioner Claufelter?
Thank you, Mr. Bristol. I have no questions for you.
Okay, I have one question. It's a follow-up to Chair Mitchell's question and the hypothetical that I asked earlier today. So hypothetically, let's assume that an ISA is executed and then affected system upgrades come to light. I assume that within PJM's OAT or within Manual 14, is there a process that's laid out to determine who bears the risk if that happens?
Well, so I don't see that hypothetical occurring, because you don't get to a signed ISA with no knowledge of an affected system impact. If there's a flag risk, you either identify that there's an affected system upgrade in the impact or facility study. If for some reason you're pressing for an ISA and the studies aren't done, but there's a known effect that could occur, that would still be written into the ISA into Schedule F. PJM will not tender an ISA if there's this risk, or if they've talked to the various affected systems and one of them hasn't answered yet. PJM won't issue the ISA. They'll just hold on to it until they get the answer. And then once they get the answer, then they'll reflect that answer in the ISA. There just isn't a circumstance where you can get to an ISA where PJM says, hey, we tried to talk hypothetically to an affected system and they didn't answer, so we're issuing the ISA anyway. That's just not how PJM's interconnection study process works. It's not how their joint operating agreements with affected systems work. And they have a joint operating agreement with Duke. So they have an obligation in their tariff to coordinate with Duke before they get to an ISA. And if they, in order for PJM to get to an ISA and ignoring something that Duke told them or not touching base with them, they would have to violate their tariff to get there, and they just don't do that. And that's not what happened here. I mean, we got to a signed ISA after full coordination with Duke on two different queue positions and two different clusters. So At the Alpha Delta 2Q, Duke looked at this project's POI. The POI didn't change. We just added 50 megawatt to the second Q position. So for this location on their grid, they looked at the Alpha Delta 2Q, came back, looked at it again at the Alpha Echo 2Q, and Duke continued to affirm there are no affected system impacts due to this Q position. Now, the reason, Duke hasn't published the Alpha Echo 1 or 2 studies on their Oasis yet is because there are other projects in that cluster that may or likely have an affected system impact. The focus of their study is to get those right. But ours, they've already checked the box and said, there is no impact on this one. Duke and PJM have tied out that there is no impact. So they've put this one to bed and said, there is no impact. There will be no impact. No further studies required. So.
Okay, thank you, Mr. Bristol. Before I move to my next question, I think Chair Mitchell had a follow-up question.
I do, and thank you, Commissioner Duffley, and thank you, Mr. Bristol, for hanging in here with us. I actually have 2 questions, Commissioner Duffley, if I may. Mr. Bristol, first, I'm going to take the one that follows up a comment you just made, the joint operating agreement between PJM and Duke, just as an example. Does the joint operating agreement obligate PJM? I'm sorry, between PJM and Duke. Does the joint operating agreement obligate PJM to confirm affected system impacts with Duke before entering into the ISA?
It does not explicitly state those words.
Okay. The second question for you. I mean, I assume you've heard Mr. Lawrence's testimony before us this afternoon, and you've likely read the public staff's position in this proceeding. And again, I understand what the public staff's recommendation is on your particular application, on the LLC's application, and I understand the facts of this case. But I'm asking you to sort of help me understand here that the public staff seems to take the position that the charges associated with interconnecting a particular facility can change post-ISA. I've heard the public staff express uncertainty with respect to those charges. And I hear you saying something quite different, that once the ISA is signed and a fully executed document, no additional charges are going to materialize. So it just, those are disparate positions. So how do we reconcile them? What's the right position?
Well, I mean, I believe my position is the right position because we are developing and interconnecting hundreds of megawatts of projects all across the PJM footprint. And, we have, there's affected system analysis going on in the west part of PJM's footprint with adjacent ISOs and RTOs like MISO and SPP. And sometimes those affected system studies hold up a project and we have to wait and wait and wait. And then sometimes we're going directly to MISO and asking them, why can't they get our study done, even though it's on a PJM side, or SPP? Why can't you get the study done? It's on the PJM side. And we're sitting there, it'll be kind of the opposite of this one, where we'll be sitting there begging for our ISA and they'll be holding it up saying, you can't have it until the affected system analysis is done. So my practical experience with PJM is they will not issue an ISA until it's done. And I got the opposite in this case. I've got 2 impact studies that say there are no affected system impacts. I've seen examples with other TOs where PJM will issue an impact study on the affected system section. It'll say to be determined in the next study phase. And then they'll issue the affected system analysis in the facility study report, right? That didn't happen here. They issued the affected system analysis right up front in the impact study. They didn't wait for the facility study as they do in some cases, or they did not wait for an adjacent ISO or RTO that is backlogged in their affected system analysis. That just did not occur here. They did the studies, they put it in the report, and then both parties to that affected system analysis both sent confirming emails that neither one of these queue positions have an affected system impact. And then you end up at the ISA stage. There would be a Schedule F to the ISA if there were affected system impact. It was FERC filed. There were no timely interventions, and we're just sitting there waiting for FERC to agree the ISA is approved. And if there was some dispute between DEP and PJM, I would expect DEP to intervene in that docket. and express concern, but that did not happen here. So, you know, this is more information than we typically get from the affected systems at this stage of a process. To have it in the reports, in the ISA, and confirming emails, that is like every box we could possibly check, other than Duke posting the overall cluster study report on Oasis, which they just haven't got around to because there are other projects that do have an impact. You know, we're waiting for that, but and I don't agree with what Mr. Lawrence said about the Alpha Delta 2 publication that Duke did put out there. That study's done. They are not coming back to reopen Alpha Delta 2-160. They state plainly it's these 4 projects, and if something changes amongst those 4 projects or any triggering project that have those 4, they'll reissue for those 4, but they're not going to bring in extra Alpha Delta 2 projects. They have ruled in, ruled out what's part of the study, and then it's not those 4, and the costs associated with those 4 could change over time, but no new projects are coming in. It's done.
All right, thank you, Mr. Bristol.
Hey, Mr. Bristol, you're almost done. I did have a question with respect to the public staff's conditions. So I think I heard today from potentially, well, I'll just say I think that I heard today with respect to condition number 2, and I'm on Evan Lawrence's testimony, page 10, about filing a verified statement acknowledging that under Duke's affected system business procedures and PJM's oath, the interconnection customer is responsible for all affected system network upgrade costs assigned to the applicant's facility without reimbursement, if any. So do you agree with that condition? Do you feel like you've already made that verified statement?
I want to get to exactly what you're talking about. So I'm on page 10 of Mr. Lawrence's testimony. Is that where we're at? So at
Yes.
Page 10, line 7, is that where we are?
Correct. Do you feel like I'll give you a minute to read it, but the question is, do you feel like you've already made that verified statement?
I believe that I don't believe that this statement is applicable because our affected system upgrade costs are 0, and Mr. Lawrence seems to keep thinking that there's going to be some future study that's going to change that, and it's not. There is no future study to be done here, and and we have an email from Duke saying there are no affected system impacts. How can we go any further than Duke saying there's no affected system impacts? That is straight from the affected system entity telling us there's no affected system impact. So if the public staff would not accept an email from Duke, I'm not sure what they would accept. It doesn't seem like they would accept anything.
So I guess my next question is, if you continue to say that there are no affected system impacts, then I'm having trouble understanding why you wouldn't just issue a verified statement that at this time, as you understand it, there are no affected system costs for the facility.
Yeah, I mean, I'm willing to continue to state, I don't know about the context of the conditions, but I'm willing to continue to state, as I stated in my testimony, that there are no affected system upgrade costs applicable to this project.
Okay, and so you wouldn't have a problem with a verified statement to that effect?
I guess it depends on what the verified statement is. I'm not sure. I'm concerned that there's going to be some condition that we can't meet because, we've got an email from PJM, an email from Duke, and we've got the filed and soon to be FERC approved ISA that all say there's no affected system impact. I don't know what more we can say that is even more verifiable than that. So it seems like that there's sufficient evidence on the record to verify that there's no affected system upgrade costs. I don't know and that's why we're concerned about these conditions. We don't know what more we can say to meet a condition that is obviously being met. It's $0 and the ISA is FERC filed and soon to be approved. I think the facts are clear.
Okay. So with, I think, condition number 4, which is on line 8, begins on line 18 of Mr. Lawrence's testimony on page 10. Your testimony suggested that there would be issues with financing. Can you think of language that would satisfy public staff's concerns but not cause the potential uncertainty? Could this be reworded in such a way that we satisfy the public staff's concerns and not cause additional financing time?
I mean, prior to this hearing, we tried to reach agreement with the public staff on what the facts were in this case. And no matter what evidence we showed them that there are no affected system impacts, they didn't seem to be comfortable with what we're showing on the record here, that PJM's done the studies, Duke agrees that there's no affected system. We've shown them all that information, and they still seem unswayed by the notion that there are no affected system impacts for this project. And we would like to be able to reach, agreement with the public staff to allay their concerns. We think our project is the one that, there are no studies, there is no uncertainty. We're like the kind of the prime example of what y'all want on a PJM interconnecting project with no affected system impacts. We've proven everything that needs to be proven, and more projects should look like ours is the way we look at it. So.
Okay, thank you, Mr. Bristol. I have no further questions. Questions on commission questions? Ms. Coxton.
No questions from the public staff.
Ms. Ross?
Just very briefly, Mr. Bristol, I think we've covered this, but I want to make sure it's clear for the record. Is part of the position that Oak Trail is being asked to prove a negative in that there are no affected systems?
Excuse me, I didn't hear your question.
Oh, yeah, excuse me. Can you hear me okay?
Yeah, I can hear you okay. I didn't know if you were making a statement or asking a question.
Sure, absolutely. No, I was asking, is it fair to say that part of the issue is that Oak Trail is being asked to prove a negative, that negative being that the studies were done and there's no affected system?
That's what it seems that way, yes.
And to be clear, the studies for Oak Trail are done.
The interconnection studies for Oak Trail, including affected system studies, are done.
And there was a question about whether or not the joint agreement obligated PJM to confirm affected system before the ISA was issued. Do you recall that questioning?
I recall that questioning, yes.
Okay, and your answer is there. Those exact words were not in it, but it is correct that the OAT and Manual 14A specifically requires coordination between PJM and Duke, correct?
PJM's OAT generally describes its obligation to coordinate with affected systems, and PJM's joint operating agreement with Duke is evidence that they coordinate.
And PJM and Duke regularly conduct interconnection studies, as you've described, across multiple markets, correct?
Yes, PJM has 2 Q clusters a year, and so they have to coordinate those clusters with all affected systems, not just Duke.
And to your knowledge, public staff has not done their own study in any way about Oak Trail's potential impact on affected systems for Duke progress, have they?
I'm not aware of any third-party studies alleging something different than what PJM and Duke have coordinated during the interconnection study phase of Oak Trail.
is it fair to say that we should be able to rely on Duke Energy Progress and PJM as the experts related to whether or not there's an impact to Duke's affected system?
We can rely on the fact that PJM will follow its tariff, and its tariff requires them to coordinate with Duke, and that there's nobody better at following PJM's tariff than PJM.
And nobody better at determining if Duke's system is affected by a project than Duke?
No, I would say that Duke would be the entity that would determine if they have an affected system impact caused by PJM. PJM would notify Duke of a potential project, but it's Duke that would state if it had an affected system impact or not. And I think that Duke's review of its own system carries more weight than PJM's review of Duke's system.
Fair enough. That's exactly where I was going. And it's fair to say that Duke has reviewed whether Oak Trail has an impact on its system, correct?
Duke has, and has stated there is no impact. They've affirmed for both Q positions that there is no impact.
Thank you. Now, there was some, well, let me stop there. There's an ISA for Oak Trail that we've talked about today, correct?
Yes.
And there are no upgrades reflected on Schedule F. We've talked about Schedule F. Is that correct for Oak Trail? There's no Schedule F?
Correct.
And it's your testimony that if there were known or potential concern for upgrades to Duke systems, they would be listed on Schedule F, correct?
Yes, they would be. That's not the only thing that can go into Schedule F, but if there were an affected system impact, it would be listed in Schedule F.
And it's correct that your testimony is that PJM would not have tendered or executed or filed with FERC the Oak Trail ISA in the form it is today, specifically with nothing listed on Schedule F, if the question of impacts to Duke system was not closed out.
Correct.
With that, Commissioner Duffley, we have no further questions.
Okay, thank you. I think that we have come to the end of the day. Ms. Parrott, are you still with us?
I am, yes.
Very good. Ms. Parrott, if I may, there's been a question about the introduction of evidence. So out of an abundance of caution, if you're there, would you like to make a motion that the application and the direct and supplemental testimony of Matt Crook, the direct testimony of Christopher Lohr be received into the record and treated as if orally given from the stand, and that the exhibits sponsored by each witness will be received into evidence and marked as identified when pre-filed?
Yes, Commissioner Duffley, I would. Thank you.
Okay, are there any objections to that motion? Hearing none, that motion will be allowed. Is there anything else for the good of the order today?
We would have a brief closing if the commission would entertain us, understanding it's late in the day.
Yes, please make it short though. We have a hearing that begins at 6 p.m. tonight.
You all have a very fun day. Thank you. And we thank you for your time today. We certainly understand the public staff's obligation to represent the using and consuming public and to protect the using and consuming public. And we understand the issues raised by affected systems. However, Oak Trail does not impact Duke Energy as an affected system, and it places no risk on the public. As you've heard, no upgrades to Duke systems are required for Oak Trail to interconnect and operate. While the commission is currently considering policy issues related to affected systems and has asked great questions on those today, Oak Trail should not needlessly be drawn into those policy discussions. Oak Trail is a late-stage project. Site control was obtained, the county use permit was applied for and received, consultation with environmental agencies occurred, approvals have been received, as you heard in testimony. The CPCN was applied for, and a power purchase agreement was entered. In the background of all that development activity, the interconnection process was started and completed. PJM followed the procedures in its OAT, including coordinating with Duke Energy Progress as a potentially affected system. Duke completed its affected system review and determined Oak Trail had no impacts on its system. And this is not a surprise, in part because we've talked about today, because the project is in Currituck County, far from the scene. Not to say that some project in Currituck County couldn't have affected system impacts. Oak Trail does not. Upon completion of the interconnection study process, PJM tendered an interconnection construction service agreement and an interconnection service agreement to Oak Trail. Oak Trail executed those contracts, returned them to PJM. PJM in turn executed them and filed the ISA with FERC. The ISA, which has been provided and talked about a lot today, contains no terms or provisions related to required upgrades to any affected system. Now, we argued that it is irrelevant that the AE2 cluster study has not been complete. And we know that through communication from Duke. We know that from communication with PJM. But mostly we know that because of the signed executed ISA that contains no Schedule F provisions related to any open issue of affected system. Oak Trail does not create an impact on Duke's system. Turning to the conditions recommended by the public staff, all of which relate to affected systems. Those are not tailored to the facts that we presented here today for Oak Trail. And we've talked about the fact that they create confusion and have an unwarranted impact on the ability of this project to obtain financing, to close on that financing, to proceed with construction based on that financing. Each of the conditions creates uncertainty for Oak Trail and does nothing to protect the public. The conditions, these same conditions may be perfectly reasonable for other projects, merchant or otherwise, that have impacts to affected systems, but they're not reasonable for Oak Trail. And we've noted that the staff has not proposed them for similarly situated projects, understanding those are not precedential, but asking the commission to consider it. We talked about Oak Solar, formerly Gaston, in EMP-114. That is where the public staff did not raise these conditions. The order has not been entered yet, but the parties have agreed on those conditions. We talked about Camden in 109, where the commission has entered an order. Oak Trail is similarly situated to Oak Solar and to Camden Solar for a number of factors. The most important being the ISA and the lack of impact to affected systems, because those are the conditions we are talking about here today being unreasonable. Furthermore, we would, put forward that the proposed condition for the proposed condition D in Mr. Bristol's testimony, which requires the revisions of cost estimates to be provided to the commission, addresses any concern that there could be a change and the commission would not be aware of it. Oak Trail has executed an offtake contract with a large commercial and industrial customer for the entirety of the output. It is a viable project that is ready to obtain financing and begin construction, and to saddle Oak Trail with irrelevant conditions for this critical permit is unfair, unreasonable, and does not serve the public. In conclusion, the public policy interest present with Oak Trail is the development of economical, clean, renewable energy. For all the reasons discussed today, these requested conditions are tailored. These requested conditions, are tailored to the facts of Oak Trail and are reasonable to keep the commission informed and to protect the public. So we request that the commission expeditiously act to issue a CPCN with the Oak Trail proposed conditions A through D provided in Mr. Bristol's testimony. We thank you again for your time.
Okay, thank you, Ms. Ross. Are there any other matters before we adjourn? Okay, hearing none. Thank you, Ms. Coxton. Thank you, Ms. Mitchell. Chair Mitchell, Commissioner Clodfelter, we're adjourned.
Thank you.
Thanks, Hubert. Thanks, John.